next case is Barry Smith versus the City of Stow et al. Each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. Please let me know if you do wish to reserve time for rebuttal, as I'll be keeping track of the time. The arguments are being recorded, so please stand behind the podium and keep your voices up. You should not use the names of children or victims. You can use initials or generic terms in your argument, like the child should identify. The judges have read your briefs, and we are ready to proceed when you are. And would the appellant like to reserve time for rebuttal?
Yes, Your Honor. I'd like to reserve 4 minutes, please.
Okay. Then you may proceed when you are ready.
Thank you. Good morning, Your Honors, and may it please the Court. My name is Kevin Gross, and I'll be here on behalf of Appellant Officer Barry Smith. The first issue I'd like to address is the fourth element of Officer Smith's prima facie case of discrimination. The trial court erred when it found that Smith did not satisfy that fourth element. To be sure, Ohio law only requires that Smith have, quote, some evidence as to each element of his prima facie case. Smith was not required to conclusively prove his case at the summary judgment phase. He only needed to have some evidence for his prima facie case. Smith can establish the fourth element in 3 different ways. The first way is quite simple. I think it's low-hanging fruit. 2 Caucasian officers were promoted over him after the 2014 promotional test scores came out. Officer Stephen Miller was promoted over him in spring of 2014, and then Officer Eric Durker was promoted over Smith in spring of 2015. Those 2 non-protected persons were promoted over Smith. By that alone, he has established the fourth element of his prima facie case, that 2 Caucasians were promoted over him. First it was Stephen Miller, then it was Eric Durker. The second way that Smith can establish the fourth element of his prima facie case is because the position that became open by the retirement of Sergeant Dutton went unfilled. Sergeant Dutton unexpectedly retired in the fall of 2014, and Chief Film and the City of Stow were made aware of that in the summer of 2014. It came as a surprise, and that position was never filled by the City of Stow. That's another way that Officer Smith can establish that fourth element, that Sergeant Dutton's position remained unfilled. The final way that Officer Smith can establish the fourth element is by establishing that Eric Durker is similarly situated to him. That's where the trial court erred. The trial court only addressed the similarly situated standard on the Fourth Amendment. It did not address whether the position remained unfilled and whether the position was filled by individuals outside of the protected class. It did not address that in its summary judgment opinion. Durker is similarly situated to Smith because they both participated in the same promotional exam at the same exact time under the same exact conditions. He had the same exact test scores that were hired by the city to conduct the civil service exam. What's more is that they scored within 0.2 of a point of each other, with Officer Smith scoring higher on the objective written exam, and with Officer Durker scoring higher on the subjective part of the exam. This is some evidence that that a non-protected person was treated better than Barry Smith when they were similarly situated. And that's the third way that Barry Smith can establish that fourth element of the prima facie case, that a jury could find that he and Eric Durker were similarly situated. Lastly, Durker was treated more favorably than Smith because he did receive a promotion to sergeant, while Smith did not. And that happened when Smith had more tenure in the department than Durker. The second issue I want to address is Smith's retaliation claim. The trial court found that Officer Smith could not establish a causal connection. The trial court erred because it failed to consider the fact that the first opportunity that Chief Film and Stow had to retaliate against Smith occurred when it did, a year and a half after the protected activity. That's because of how the civil service exam functions. In order for there to be a promotion, there must be a civil service exam, and there must be someone within the top three, the so-called Rule 3, to be promoted off that list. At the time when Barry Smith engaged in protected activity, on June 9th, 2015, by filing a charge of discrimination, when Eric Durker was chosen over him for promotion, the first opportunity that Chief Film and the City of Stow had to retaliate against him came in October of 2016, a year and a half later. That's because at that time of 2015, when he made the charge, Smith was number one on the list. He was first in line to be promoted. In fact, he was the only one who could be promoted based on Rule 3. The Rule 3 says only officers who score in the top 3 of the exam can be promoted. Smith scored 3, the first 2 were already promoted. He was the only one who could fill the position. But instead of promoting Smith to the sergeant position left vacant by Dutton unexpectedly in 2014, Chief Film in the City of Stow allowed his #1 test score to expire a year and a half later. It expired on October 15th, 2016. Then, 2 weeks later, Chief Film writes a letter to then Mayor Drew, where he communicates his intent to want to fill that position left vacant by Dutton in 2014. He says, and I quote, "We have been one supervisor short since the fall of 2014. If Chief Film's been one supervisor short for 2 years at this point, why didn't he fill it?" He didn't fill it because Smith was #1 on the list for a year and a half, and he didn't want Smith to get the position. That's some evidence of a causal connection between Smith's protected activity in June of 2015 and the adverse employment action, which occurs when his test score expires after October 15th of 2016. It was then that Chief Film wrote the infamous letter that he now wants to fill that position left vacant by Sergeant Dutton. And at his deposition, when I asked him, "Is that who you were referring to? Were you referring to wanting to fill Sergeant Dutton's position?" He said, "No, that wasn't it." And he sat there and he thought, well, there's no one else that retired from a sergeant position in the fall of 2014, so yeah, it was him. You got me. What's more is, in a letter written to the mayor on June 23rd, 2015, about the department, Chief Film does not want to fill that sergeant position that Dutton left vacant in the fall of 2014, unexpectedly. He doesn't speak of it, never mentioned it. Why? Because he knows Smith is #1 on the list. He knows that Smith is the only person he can promote to that position. Then, in his October 31st, 2016 letter, once Smith's test score expires and he's no longer #1 and the only person who can be promoted, then he wants to fill it. Chief Film wants to fill the position only after he knows Smith That also is some evidence of a causal connection between the adverse employment action that came when his test score expired and his engagement in protected activity in June of 2015. So this isn't a typical case where you see a close temporal proximity between the protected activity and the adverse employment action. We see that mostly in the private sector, where hiring and firing can be done with the stroke of a pen. This isn't the same. There's city ordinances, there's political processes that has to be followed. There's a budget that has to be approved, that has to be followed until someone can be promoted. And in this case, Barry was the only person who could be promoted when he should have been, when he was number one on the list. And that's the causal connection between his protected activity and chief film letting his test score expire. As to the initial points that we discussed at the beginning of this argument, there have been 2 Ninth District cases that have established that when a non-protected person is chosen over an African American like Smith for promotion, that establishes the Fourth Amendment of the prima facie case. The first case is called Atkinson versus Akron Board of Education, and the site is 2006 Ohio 1032. And the second case is Howell versus Summit County.
And counsel, I do want to let you know you're moving into your rebuttal time.
Thank you. I'll reserve the remainder for my rebuttal.
Okay, you'll have 3 minutes and 50 seconds to get your rebuttal.
May it please the court, my name is Michael Karst, and I represent the appellees in this matter, the City of Stow, and Chief of Police Jeffrey Fiddle. The trial court correctly granted summary judgment on all of Barry Smith's claims, and this court should affirm for 3 main reasons. First, Smith cannot establish a prima facie case for failure to promote him to a position that was eliminated and that no member outside of a protected class was selected for that position. Second, an 8-month temporal gap, let alone a 2 or 3 year temporal gap, is insufficient to establish a prima facie case of discrimination or retaliation. And third, Smith cannot identify or create an issue of material fact that the city's decision to promote based on order of score in a civil service examination is pretext to unlawful discrimination. As to the first point, in this case we're dealing with what Mr. Smith alleges as 3 promotion opportunities. The 2014 civil service examination established a rank of 5 officers. Barry Smith scored 3rd out of 5. A position became a sergeant by the name of Steve Dutton, retired. We've been calling that the detective sergeant position because Mr. Dutton oversaw the detective bureau. When Mr. Dutton retired, the city made the decision, Mayor Klein in particular, that instead of filling that position, they would allocate resources to hire other patrol officers. Mr. Smith was not considered for that position, nor was any other individual considered to fill the detective sergeant position. The prima facie case, and this course established in Fox versus Lorain County Metro Parks, the prima facie case requires that the plaintiff be considered for the position, is one element, and second, that someone outside of the protected class be hired for the role. In this case, there is no dispute that no one filled the detective sergeant position. There was no one hired after the detective sergeant, after Sergeant Dutton retired until 2018. Which leads into the next point about the temporal proximity here. The gap between Mr. Smith's protected activity, he filed an internal complaint of harassment and discrimination, and then he filed an EEOC charge. The gap between those protected activities and when the city made a decision to hire someone is at minimum 8 months. And if we expend it onto his EEOC charge to the hiring in 2018, we're talking multiple years. This court held in Nimgard versus Shin Etsu Silicone that temporal proximity alone is insufficient to establish a prima facie case if it's, and I'm quoting here, especially where events are separated by more than a few days or weeks. There's no dispute here that our temporal timeline is much longer than a few days or a few weeks. We're talking months and years between the two events. There's no evidence in the record, and there's no case law cited in the briefs, that expiration of the civil service examination scores, allowing those scores to expire, is an adverse employment action. First, the city did not have control over when that test expired. That's set by civil service rules long in advance of this. The adverse action would be hiring someone else for the position. And that happened in 2018, not when the scores expired in 2016. So we can't use that, the plaintiff can't establish a prima facie case on time alone because the scores expiring isn't an adverse employment action against him.
So you're referring though only to the 2018 filling the position, not about the other two positions?
Correct. So as to the other two positions, one, when the decision was made not to fill the vacancy, that occurred before Mr. Smith filed his internal complaint, before he filed his EEOC charge. So obviously those events couldn't have caused retaliation, or not sufficient to be retaliation. There was a decision made to promote Eric Durker after a retirement. That did occur after the internal complaint of harassment. But again, that's still an 8-month difference between his internal complaint and when Eric Durker was promoted. That's the closest time that we have between protected activity and an adverse employment action. Then let me focus then on the other two hiring decisions, the promotions of Eric Durker and the promotions following Matthew Reed's retirement. So the trial court held that Mr. Smith did not establish a prima facie case because he was not similarly situated, he did not have similar qualifications as the individuals who were selected for the position. The Sixth Circuit Court of Appeals held that the fourth element of that prima facie case is that, a quote, an individual of similar qualifications who was not a member of the protected class received the job. What the trial court looked at was that the ranking on the civil service examination was a qualification. Being the top ranked individual on the test was a qualification to receive the position or to receive the promotion. And so because Mr. Smith was not on the top of the rank at the time the promotions were made, he did not have similar qualifications to the individuals who were selected for the position.
It seems like the trial court's mixing two different concepts. I mean, with the similar situated and with just the regular prima facie case when somebody is not hired and somebody outside the protected class is hired.
I agree, Your Honor, in that there were lots of issues that the court decided. Some, like the harassment claim Mr. Smith brought, would use that similarly situated test. If the court finds that Mr. Smith established a prima facie case, this court has held in Coventry Township v. Ecker that so long as there are other valid grounds that are available to support a grant of summary judgment, that this court can affirm. And so even if the court finds that Mr. Smith established a prima facie case just for the one promotion, or the promotion of Mr. Reed, promotion of Eric Durker, that this court can still affirm because Mr. Smith has not established pretext, that the legitimate business reason of the city, that being promotion based on score, was somehow pretext to unlawful discrimination or retaliation. Again, it is undisputed, Smith ranked 3rd out of 5 of the promotional examinations. It's undisputed that the 2 individuals who were hired before him scored better. It's also undisputed that the majority of promotions, the historical precedent at the city, was to promote in order on the civil SOAR examination.
And that's what I was going to ask you about, because there was some evidence that was presented that the city didn't always do that.
Not always, I agree. It is not uniform, and it's not required by the civil service examination or the civil service rules. What the rules require is we had 5 individuals for the 2014 exam who took the test and passed with qualifying scores. Not all 5, the city could not select from all 5. It could select from any one of the top 3 scores. That is, again, what's referred to in the record as the rule of 3. In very few occasions, Mr. Smith testified at his deposition to recalling it happening once, where someone, not the top-ranked individual, was selected ahead of the top score. So it wasn't always uniform, but that was the majority of the time was in order of rank, and that's what occurred here. To establish that, a matter of pretext as to the city's decision to select other candidates, this court held in Pallado v. Board of Education in Nordonia Hills that Barry Smith would have to show either that the city's justification for the promotion had no basis in fact, that it did not actually motivate the city's decision, or third, that it was insufficient to motivate their decision. Yet there is no dispute of fact that Miller and Durker scored higher than Smith on the examination. That means that there was basis of fact for the city's legitimate non-discriminatory reason. The profit reasons did motivate the action. Deposition of Chief Film, Merrick Klein, established that they promoted based on rank, this 2014 civil service examination, and we agree. Had Smith ranked higher, had he scored better than the other candidates, he would have been promoted. Finally, the proffered reason was sufficient to motivate the decision. The deposition testimony from Chief Film and Mr. Smith confirmed again, the vast majority of promotion during Smith's tenure was done based on rank. The city followed its historical practice when it hired based on that rank. So because Smith cannot create an issue of material fact that the city and Chief Film discriminated or retaliated against them, this court should affirm the trial court's order granting summary judgment on all claims.
Thank you, counsel. You may proceed on rebuttal. We have 3 minutes and 50 seconds.
Thank you, Your Honor. In rebuttal, the first point I'd like to address is the argument made regarding pretext. That promotion in the city of Stow has always been based on test scores. It's simply untrue. When Chief Film himself was promoted to sergeant, he scored number 3 on the sergeant's exam, just like Smith. However, he was promoted over number 2 to a sergeant's position. Then, when Chief Film became chief, he promoted the number 2 score on the sergeant's promotional exam again over the number 1 score. That was in 2018. This argument that the city of Stow and Chief Film always promote based on the test score.
Well, I'm not even sure that's what they're arguing. Historically, in majority of them.
And based on.
I'm sorry, I didn't mean to interrupt your train of thought, but I was just trying to figure out whether the argument was that based on a particular chief of police, that it was based on the scores of the test takers. And at some point in time, historically, that may not have been the case, that it was just the rule of three. Anyone in the top 30 could be promoted based on whatever criteria they want to use then. But I'm not sure without reviewing everything, which we will undoubtedly do, as to what that precedence was.
Thank you for the question, Your Honor. And it is a point that Chief Film has argued, that it wasn't him who promoted him to sergeant when he scored number 3 over the number 2 score. Of course, that's correct. That couldn't happen. It would be impossible. However, when he did become chief, he did promote the number 2 score over number 1. So his position and the city's position that they always promote based on test score, and that's why Smith wasn't promoted over Durker and Miller, it doesn't have a basis in fact, because the city has shown on previous occasions that it is willing to promote outside of the test scores and how they rank. The second point I'd like to make on rebuttal, Your Honors, is that this is the only time that a supervisory position has allegedly been eliminated. Never before has it been allegedly eliminated.
Well, was it eliminated? Was it actually abolished from the table of organization, or was it just not filled?
It was unfilled, Your Honor. In a letter
So it's
that,
still on the table of organization?
yes, in a letter that then Mayor Klein wrote to the EEOC in response to Smith's charge, she wrote that it was decided, after discussing with Chief Film, that Sergeant Dunn's position would remain unfilled, quote, for the foreseeable future, end quote. So the decision was made to not fill it. It was not eliminated. The position was not eliminated. But this was the only time that a supervisory position went unfilled. And I want to go back a little bit to 2014 when the test.
Okay, Counsel, your time is running out, so please wrap up.
Thank you, Your Honor. I don't think I have time to make the last point, so I will take a seat. Thank you very much for your time this morning.
Thank you very much, both of you, for your presentations. The court will take the matter under advisement and issue a decision in due course.